I want to talk to you a bit more about EIA. There's always a danger with this that we end up with overlaps and so on, and I have actually realised that what I was intending to talk about would take about 30% of Deborah's talk, and so I'm not going to talk about one element of one of the European Court judgments. What I'm really going to be talking about is EIA screening, and you might well think, why? Because essentially nothing's really changed in terms of screening, in terms of the legislative provisions, but the significance of screening has suddenly been bombed to the front with the Planning and Development Amendment Act, and I'll go into why later on. So I want to say a little bit of background about EIA and talk about 3 of these 4 EIA issues. I'm going to leave split decision making to Deborah, but I want to talk about retention applications, the significance of the screening issue to do with retention, and also talk about EIA and agricultural development, because there's ongoing a case against Ireland on that. My paper covers a lot more than just this, and so this is just a bit of a chunk really, and kind of my idea was with the paper would really cover all the other bits of EIA that I didn't cover in an earlier talk I did here in 2009, which was on EIS content. Now that actually got written up as a Planning and Environmental Law journal, so I'm not really going to go into EIS content, which perhaps is actually now much more certain. There was always claims that EIS documents were invalid simply because they didn't fulfill the statutory requirements and so on. A lot of that seems to have now died back a bit simply with case law. What we'll see really in relation to EIA is actually that there's still quite a lot of uncertainty about what this is all about. Talking about big projects, the best figures I've got, which this came out quite recently from the Local Government Management Services Board, at least when the end of the Celtic Tiger was still just about roaring, there was about 255 EIS documents submitted with planning applications to planning authorities. On top of which, there are EIS documents submitted directly to the EPA and to Bord Pleanoloa for local authority development or for strategic infrastructure. So you might have about perhaps even 300 EIS documents being submitted into the system, at least before the current close down. It'd be very interesting to see what the 2010 figure is, but we'll have to wait for that. So it's actually a very big business for these very, very contentious projects, and it is good business for consultants for obvious reasons. And all this falls back to a directive which is a 1985 directive. And what seems quite incredible is that here we are 20 years later and we're still talking about what does this really mean. And I think that will become very apparent as I go on. And the other thing I would say is that please, if you disagree with me, please, if you don't want to talk, either talk to me afterwards or send me an email or something like that saying, Duncan, I think you're talking a lot of rubbish here. It would be really useful to know that if there's other ways of interpreting some of these provisions and so on. The EIA directive has now been amended 3 times by Directive 97/11, which essentially picked up on a lot of the European Court of Justice case law, simply on areas of unclarity about the original directive. It was also amended in 2003 in relation to access to justice and the Aarhus Convention. And there's also a minor amendment to the Annex 2 list of projects by the 2009 amendment, simply putting in carbon capture and storage as an EIA project for the first time. Transposition, it is quite difficult sometimes, particularly for the non-planning permission projects to actually work out how this directive is transposed. But mainly it's in relation to by the Planning and Development Acts and the Planning and Development Regs, separate provisions from the Roads Act. But actually for some of the more obscure things like foreshore, you have to go back to the old 1989 regulations and trawl through all the amendments. And my goodness, there is a huge number of them, really, which also maps out all Ireland's problems of actually trying to comply with this directive and transpose it effectively. So, and good luck to you if you have to go through the 1989 regulations. In relation to the screening issue, what I'm going to do is really talk you through really how the directive looks at projects that should be subject to EIA. And then looks at how, and within that kind of covering how the Planning and Development Act, particularly the Planning and Development Regulations, actually do that. And essentially the directive sets down as 2 annexes. Annex 1 projects where EIA is always compulsory. Annex 2 projects where the decision about EIA is devolved to, at least to a certain extent, down to member states. And the other important thing, and that's already been mentioned, is changes and extensions to these projects may also warrant EIA. So essentially, the screening issue is about deciding when EIA is needed. For Annex 1 projects is relatively simple because the directive simply sets it down. So the thresholds here are the same in every EU state. And this is transposed mainly as Schedule 5, Part 1 of the Planning and Development Regs. So power stations over 300 megawatts always need an EIA, no matter which member state it is. Very large quarries over 25 hectares, which is a pretty massive quarry, always warrants an EIA as an Annex 1 project, and so on. So there's a load of thresholds which are built into the directive. In relation to the Annex 2 projects, things are a little bit more complicated because, as I said, it's devolved to member states to sort them out, either using thresholds or criteria or a case-by-case examination, or both. And I think really Ireland essentially has set thresholds but also requires a case-by-case examination. UK's done it slightly differently. I don't know about some of the other states. When a case-by-case examination is needed, the directive hasn't left member states to kind of decide on their own. Actually has set down some quite clear criteria in Annex 3 of whether or not significant effects to the environment are actually likely. So we have Annex 2 transposed mainly by the second half of Schedule 5 of the Planning and Development Regs, plus this concept of sub-threshold development. Now, I will explain sub-threshold development in a minute, which is sat within Articles 92, 102 and 103 of the Planning and Development Regs, which is essentially a case-by-case evaluation. And with the result that Annex 3, which is basically telling you when there should be a case-by-case examination or when thresholds and how to decide thresholds, is transposed by Schedule 7 of the Planning and Development Regs. So if this isn't clear, I'll kind of explain this as how it works. Let's take a waste facility. I like this. I took this photo years ago. It's a landfill called Fowl Lane, which I think Jonathan may actually know in Manchester. Does that ring a bell? I thought it's a superb name for a landfill. It's no doubt a green field now. Under Annex 2, Annex 2 just simply says installation for disposal of waste projects that are not Annex 1 will need an EIA when the significant effects of the environment are likely. Now, Ireland's selected a threshold by setting an intake of 25,000 tonnes. And this is pretty low, to be honest. And, the thresholds in Ireland in general, with certain exceptions, and I'll come to the exceptions later on, are actually pretty low. And that's one of the reasons maybe the whole screening issue hasn't really had the prominence that perhaps it should have done up to now. So Ireland set the thresholds, and there's a load of thresholds you'll find for Annex 2 projects in Part 2 of Schedule 5 of the Planning and Development Regs. Wind farms, 5 turbines are over 5 megawatts, automatically need an EIA. There's no need for the planning authority to decide whether or not these have significant environmental effects. They're being told by the legislation, this needs an EIA. Overhead cables over 200 kilovolts, slaughterhouses. And then you get into some of the other ones, which I think are quite interesting, particularly in relation to screening. Industrial estate development projects over 15 hectares, urban development, which can virtually mean anything. There's some case law I mentioned in my paper about that. In a business district, any urban development over 2 hectares automatically needs an EIA. And I'll come back to the industrial estates and the urban development projects in a minute. So all these thresholds throw the projects automatically into EIA. But then Ireland also requires a case-by-case evaluation for what are called sub-threshold projects. So projects, say, for waste under 25,000 tonnes, there is a need to consider whether or not EIA is needed because the particular project may have significant effects to the environment. For instance, a composting plant of 15,000 tonnes may be deemed to have a significant effect to the environment if there's concerns about odour and so on. And it's really the sub-threshold projects that really things get very tricky, particularly in relation to the new Planning and Development Amendment Act. So essentially it gets tricky because essentially when is this screening decision needed? Do we have to screen every project? Now, from the morning, it seemed that we're almost needing to screen every development proposal in relation to AA. Are we actually going through? Is this actually implying that we're having to screen every project for whether or not this is sub-threshold development? So, any industrial estate below 15 hectares, does anything need screening if it's an industrial estate? Does an extension to a unit involve potential sub-threshold development and seems to need screening? Tricky one. The similar thing with urban development. Anything in the urban area is urban development. Does this all need screening? Now, really up to now, you'd say, who cares? Because a lot of this stuff's really pretty trivial stuff. The chance of it going to judicial review is not that great, and the chance of actually getting leave is not that great as well, as we know in Ireland. But at the same time, for the reasons I'll explain in relation to the Planning and Development Amendment Act, these things become much more important now. So this is really perhaps why some of these screening things really hasn't received the prominence that perhaps it should have done in the past. And then if you think about not only this, in relation to changes and extensions, there's various thresholds. There's an Annex 2 threshold, which is actually quite difficult to understand. I mean, it looks quite simple until you start thinking about it. 25% or 50% of the appropriate threshold, whichever is the greater, which can kind of get slightly innumerates like me into a bit of a spin of exactly what this means. But again, don't forget that development below these thresholds may be EIA development when it's likely to have significant effects on the environment. So when we're talking about all changes and extension needing screening, well, okay, maybe we are, I don't know. But at the same time, if we are, this is going to have certain problems. And to give you an example of the kind of problems, there's a good example in case law of the Spire of Dublin case, which was simply a judicial review taken against Dublin City Council to grant itself permission, effectively development consent, to build the Spire of Dublin. Now, precisely what Dublin Corporation got wrong, as it was then called, got wrong in this, is difficult to unpick. They either decided that no EIA was needed for this development simply because it was over the 2-hectare threshold and completely forgot about the significant effects of the environment caveat, or they decided that this thing doesn't have significant effects on the environment. Now, patently, obviously, in probably one of the most historic streets in Dublin, it's difficult to say that this thing would never have significant effects on the environment. So for whichever reason, the original development consent for this was quashed, they had to go back in. So it does show the potential for quashing, and certainly there is, if you look in my paper, the UK courts have been quite keen for quashing. In relation to things that should have been screened. Now, there's different thresholds in relation to judicial review here, which may stop that to a certain degree here. But it is quite an interesting area. But the significance of it becomes much more important for the Planning and Development Act, as I'll show. So where's all this screening idea coming from? And essentially it's coming from Article 10, it's coming from the directive and also Article 103. Article 103.1, where a planning authority for subthreshold development is not accompanied by, when the planning application for subthreshold development is not accompanied by an EIS, and the planning authority considers that the development likely has significant effects on the environment, it shall require an EIS. So in that consideration, there needs to be some determination of whether or not an EIS is needed. And that really falls out of Article 4 of the directive, with Article 4.2 setting out the case-by-case and the criteria-based examination I explained, and then Article 4.4 saying member states shall ensure that the determination made by the competent authorities under paragraph 2, i.e. whether or not EIA is needed, is made available to the public. So the screening decision is a public decision. With the result possibly that we have in Article 103.3 of the Planning and Development Regs, the planning authority shall, in deciding under this article whether proposed development would or would not be likely to have significant effects on the environment, have regard to the schedule, which is Annex 3 of the directive. And then it goes on to say, after it's been amended, and the decision of the planning authority, including the main reasons and considerations on which the decision is based, shall be placed and kept in the documents relating to the planning file. So even if the decision is, no EIS need, if it is trivial, that decision still needs to be kept. Now, I'm not sure this is being kept very much around and about. I don't believe this is all over the planning files all over the country. The other interesting thing is in relation to the reasons issue. Because, as I said, Article 103.3 talks about the decision of the planning authority, including the main reasons, considerations must be put on the planning file. And there is case law from the Court of Justice European Union on this, Commission v. Italy, which is saying essentially there must be adequate enough reasons so that somebody who feels this isn't a right decision can actually approach either a consultant or a lawyer to say, look, have I got a case for challenging this? So the reasons have got to be substantial. And that's very important. And don't forget, the reasons have to be substantial in relation to deciding no EIA is required. So essentially, really, there's 4 outstanding current EIA issues, 3 of which are in relation to a Court of Justice proceedings against Ireland. I'm not going to be talking about C-5009 simply because Deborah's going to do that. So let's have a look at Commission v Ireland with cases 21506, which is essentially the Derry-Bryan decision, as Margaret's already mentioned. And essentially, not surprisingly, the Court of Justice of the European Union is saying that the concept of retention is incompatible with the EIA directive. Now, I came over here to work for the EPA in '96, and I remember talking to auctioneers about buying a house, and well, we was told basically you could explain the planning system, and essentially you told you that, particularly then, there were two systems. You either you go apply for planning permission, or you put the thing up and apply for planning permission later. And now myself and my wife were completely flummoxed by this. I remember going, what? But this is certainly, this is what the retention system appears. Now, I know the retention system's not really like that anymore, but certainly in '96, cast your mind back to '96, there was a tendency like that. There weren't many enforcement notices going out and about. So, not surprisingly, the Court of Justice didn't like this in relation to the to EIA development. Partly because they said very obviously that the whole retention concept undermines planning enforcement, which I think is a very interesting view, and obviously correct one. But they also felt that regularisation provisions in respect of unlawful must be an exception, whereas they felt it was actually, this was a normal process rather than an exception. The result is that the circular that came out in 2008 said that basically retention applications for EI development must be returned as invalid, and also applicants who got retention granted for EI development after the 3rd of July '08 are advised not to act on their permission. Not surprisingly, the Commission hadn't been very happy about that, because simply you can't transpose EU law and Court of Justice requirements through circulars, so that's actually changed. And that's changed with this amendment to section 3412, which came in last week. I mean, I agree with the point. It is actually quite difficult to track amendments and so on. We had 3 commencement orders last year. A new commencement order came out last week, SA 132, which commenced a few bits and pieces, including this one, but didn't commence the substitute consent. So substitute consent is still not it's enacted, but if you like, but it's not law as such. Now, essentially, in essence, the amendment to section 3412 says the planning authority shall refuse to consider an application to retain unauthorised development when the development is EIA development, or 3, requires an appropriate assessment. Or the second one is the key one here, requires a determination as to whether EIA is required, i.e. screening. And don't forget, it requires a determination as to whether EIA is required, not requires EIA. So it's anything that requires screening appears to now be subject to some sort of limbo, where actually a planning authority is obliged to refuse to consider this at all. So any retention, I think, now tell me I'm wrong, and please do, in urban development projects, for instance, does this mean that actually there's some sort of block now or whatever? This does seem to have very large ramifications, because it's not requiring a determination that EIA is actually needed, it's requiring a determination whether EIA may be required, is my reading of this. So if you think again of all the lists of the sub-threshold developments, you know, that there's an awful lot of them that may trip up on that, particularly the industrial estate development and urban development. I mean, maybe the fortunate thing is with the recession, there's not going to be much of this anyway, so we don't have to worry too much, but it does seem tricky. And the other thing is the changes in extensions provisions as well seems particularly tricky as well. Okay, so essentially, this is the bit that isn't in force, is that you've got this block on retention applications. But the intention is that rather than say you just can't get planning permission at all and you're stuck, which is really the system at the moment, you need to go into substitute consent, and as Margaret covered some of this, essentially there's a system for compulsory applications for substitute consent and voluntary applications. Compulsory applications are, a local authority goes, you're unauthorised, apply for substitute consent for your EIA development. A voluntary application is that essentially a developer decides my planning permission is dodgy, I'd like to regularise it by applying for substitute consent. As Margaret said, the downside of that is the sting in the tail, is that if you're if you're a developer and apply for substitute consent and haven't got it, then you instantly have unauthorised development. So you can't fall back on your old planning permission. So it's not going to be one that developers will really want to use to regularise their permissions that much, I think. The other thing that really gets bizarre in relation to sub-threshold development, i.e. development that does not need an EIA, to apply for substitute consent, the Act clearly says what you need to do, which it says that you actually need to apply to the board for substitute consent, and your application has to be accompanied by an EIS. Now, hang on a minute, we've already said that this project should have been screened, we accept that, but we've actually decided it hasn't got significant environmental effects, therefore no EIS is needed. But on the other hand, this says you have to put in an EIS to have a valid application. That seems to be very messy, and you see that twice. You see that in relation to not only the compulsory applications for substitute consent, but also the voluntary applications where there's a leave stage as well. So there's something not quite right, and it may be that this explains, or it is one of the things that explains why there's been quite a delay of getting the Planning and Development Amendment Act into place. So essentially you can see now that the screening thing seems to really have made things quite difficult, particularly with this new bit of the Act actually coming into force last week. Moving on now to this one, which is in relation to agricultural restructuring. This is going to really annoy the farmers. Essentially, Annex 2 of the directive talks about a number of agricultural projects which should be EIA development, including projects for restructuring of rural land holdings, projects for the use of uncultivated or semi-natural areas for intensive agriculture, and water management projects in agriculture. Now that's what Annex 2 says, and the bottom of my slide shows the thresholds that have been introduced by Ireland. 100 hectares for restructuring of rural land holdings, 100 hectares for uncultivated land, 1,000 hectares for a water management project. Now, not surprisingly, the Court of Justice of the European Union wasn't very happy about this, because it notes that these thresholds are absolutely massive. It's a massive farm to rip all the walls out and all the hedgerows out for 100 hectares. Pointing out to, the Commissioner was pointing out to the Court of Justice that the average field size in Ireland is actually 2.4 hectares. So you need to amalgamate 40 fields to actually get to within the threshold where EIA is actually needed, unless it's regarded as sub-threshold development. So you can see that, not surprisingly, the Commission's been very unhappy about this 100 hectare. It's also been very unhappy about the way, if you like, the nibbling into the rural landscape. And they actually use these two pictures, which are from this lovely atlas of the Atlas of the Irish Rural Landscape, as part of this is actually in the judgment. If you look at the middle of the black and white, I haven't got a pointer, but if you look at them, you can. Sorry, I didn't realise you could see me. Yeah, if you look at the difference between 1964 with all these walls here and this gap here, then obviously there's something very substantially happened here in relation to restructuring of the rural landscape. The interesting thing is, it was never really pointed out to the court, is that this was a 1964 picture, which is well before EIA came in, so a lot of this change could have happened at any time. But at the same time, the court was very struck by this, and again felt that the 100 hectare threshold was far too high, and missing a lot of substantial agricultural development. So the court felt that actually not only was the threshold too high, but there is actually no way of advance warning. No planner really gets an advance warning that there may be some agricultural development coming in involving restructuring of rural land holdings. So there's no EIA screening as such going on here, simply because the first thing somebody hears about it when work started and the neighbours rung up and complained. So essentially that area of the court case the Commission is very unhappy about. Ireland's proposed fix for this, which is an amendment to Section 4 of the Planning and Development Act. Section 4.1a essentially gives a general exemption for agricultural development. What's intended is to a new section, I think it's 4 brackets 4a, which says that basically the general exemption falls if an environmental impact assessment is required. Now, that doesn't seem to have pacified the Commission, who in February said that they're embarking on another court case and in relation to possible fines and so on. So this one is really very much live and obviously politically very difficult to implement in a manner which can keep everybody happy, particularly on the Dingle Peninsula and wherever. If you look on the DOE website, a very interesting document, and I know Tony's going to talk about this later, but I just preempt him slightly. There's a very interesting document appeared, and I think it appeared about Monday, which is actually the brief to the Minister for all his responsibilities under the various heads of the Department of the Environment, heritage, well, not heritage, but local government. And essentially a very interesting document there. Some of it's blacked out, like there's a bit interesting bit on Paul Begg incinerator is all black, so you can't get that. But it is very interesting, and it does say that regulations are very much in the pipeline to try and fix this, presumably amendments to the planning and development regs to fix this. So it should be quite interesting how this one's coming about. Now I'm going to skip this because otherwise I'm going to take Deborah's stuff out of it. So essentially, really, up to now, really, EIA screening was a bit of a non-event. We're talking about trivial projects, except the agricultural ones. You know, the thresholds are very low in Ireland, 25,000 tonnes for waste, it's 75,000 tonnes in the UK, plus significant effects. So it really meant that a lot of this stuff on screening didn't really come across anybody's consciousness, really, maybe with the exception of the Spire of Dublin, because all these small sub-threshold projects mainly are non-contentious. But now suddenly this thing becomes much more important when you're talking about determination of whether or not EIA is required, particularly when retention applications in general have now been blocked, as from last week, for development that should have been screened for EIA. So I hope I haven't put the cat amongst the pigeons around that, and somebody's going to tell me I'm instantly wrong, but at that risk I'll finish, and it'll be interesting to see what you think about it. Thanks very much.